This latest video from Right to Remain is about fresh claims. In an asylum claim, there are several points where you may give evidence to the Home Office or the courts. You might give evidence when you make your application around the time of your substantive interview. You'll almost definitely give evidence for your appeal if the Home Office refuse your asylum claim. But if you want to give the Home Office evidence after an appeal has been dismissed, when you're considered appeal rights exhausted, so either your appeal has been dismissed or you didn't make an appeal, then you're asking the Home Office to consider your new evidence as a fresh claim. Now, it's actually the Home Office that gets to decide if your new evidence, amounts to a fresh claim. But you'll hear people referring to themselves making a fresh claim. I've made a fresh claim, I put in a fresh claim a year ago. Even when what they're technically referring to is giving further submissions to the Home Office to be considered as a fresh claim. That's obviously quite a mouthful, so you can see why people say, I've made a fresh claim. Let's have a look at the situation you might be in that could lead to you having new evidence, further submissions for a fresh claim. What are the possible bases for a fresh claim? It might be that you've got new evidence about the original reason you claimed asylum. So the original reason you said to the Home Office and the courts, I'm not safe to go back, I need protection from the UK. This new evidence might be something like a new human rights report that's been released since you originally made your application. It might be something like an expert report that's been commissioned to talk about your situation and whether it fits a pattern of behaviour from your country. Or it might be that you have evidence about, for example, your activity in the UK. If your claim for asylum is based on political activity, maybe you've been active in a political group in the UK, and that links up to your claim for protection, why you would be in danger in your home country. If your claim is based on your sexuality, maybe you've been involved with LGBT groups. If your claim is based on religion, such as conversion to Christianity, it might be evidence about that activity that you wouldn't have had when you first came to the UK because you hadn't engaged in that activity yet. The next basis for a fresh claim might be the change of circumstances back home. So has the government changed in your country? Has there been a new law passed in your country? Have there been certain activities, certain attacks that would show that you would be in danger like you said you would be in danger? The important thing about getting evidence about a change of circumstance back home, it's not maybe that common that government changes or a new law is passed. If it does, you need to make sure that what's happened is relevant to why you say you need protection in the UK. So, for example, if there was a new law passed that was particularly targeting political opposition groups, if you had evidence about that new law, but your claim for asylum is based on your sexuality, that evidence isn't actually relevant to your claim. You need to show that the new law or a new government will be targeting people of your sexuality. The next basis of claim is a bit more of a technical one. It's if there's been case law or legal developments in other people's cases that show your case should be looked at in a new light. So this might be, for example, a new country guidance case. Maybe there's an upper tribunal decision that says, actually, this group of people in Iraq are in danger. Whereas in your case, the Home Office and the courts said the latest guidance says that people in your situation aren't in danger. If there's been a new case that means your case might be decided in a fresh light, then that might form the basis of a fresh claim. And then there's possibly a fresh claim based on a whole new basis, a new claim. So you might have claimed asylum for one reason, say political persecution, but actually now after some time in the UK, you feel able to say, I'm actually gay and I didn't feel like I'd say this early on. So you might have evidence about that, which obviously you wouldn't have submitted earlier on because that wasn't part of your asylum claim. This can also be seen in cases where someone is converted to Christianity after spending some time in the UK. So, for example, if you are from Iran and your original asylum claim was based on political persecution because you'd taken part in demonstrations against the government, that claim may have been rejected. But since your time in the UK, you've become active in a local church, and people who have converted to Christianity may be in danger in Iran. That's a completely different reason and completely different claim. So your new evidence would be about the fact that you previously felt you're in danger for this other reason. Maybe you say you're still in danger for that other reason, but you're additionally in danger for this new reason. Or maybe you accept that that previous asylum claim isn't going anywhere, but you wish to make it known about this new reason, this new claim for protection. Another circumstance that might fit into this category is if you have family in the UK that you didn't have at the time of your application. Maybe you've had a child, maybe you've got a relationship with somebody who's British, for example, or has indefinite leave to remain in the UK. That might form the basis of a new application because you've been in the UK for quite a while and your circumstances have changed. If you're in one of these categories where you think there is new evidence to prove that you need the right to stay in the UK, whether it's for the same reason as you asked for before or for a different reason, you then need to gather your evidence. You need to make your further submissions. Your lawyer might help you to get evidence, especially if you're going to get, for example, an expert report on your situation. But if the evidence you can find is available in the public domain, so for example on the internet, then your lawyer might say you need to go and find that evidence and come back to me with that evidence, and then I'll make the legal arguments. I'm not going to go into detail about that now because we've got a couple of videos about evidence and country of origin information that go into a bit more detail about where you might find that kind of evidence. When you're looking for evidence and when you gather that evidence and either you or your lawyer are arguing that this evidence should be considered as a fresh claim, you need to think about the test the Home Office will apply to this evidence. It's called the Fresh Claim Test, and it's in the immigration rules. Here the test is, and it's quite complicated phrasing, but there's some really important points in that are really useful for thinking about what kind of evidence do I need to find and how do I explain that the evidence I have found shows that this is a fresh claim. And one of the things you need to consider is that with a fresh claim, the starting point is that the decision of the judge in your appeal hearing was correct. So even though the judge has refused your claim and you probably disagree with that, you have to accept that as the starting point and think about it as if, well, the judge may have said no then, but if they could see this new evidence I found, then they'd make a different decision. So the legal test for a fresh claim, the important sentence really is that the submissions will amount to a fresh claim if they are significantly different from the material that has previously been considered, and that they create a realistic prospect of success. So there's the kind of obvious point that the material you're submitting does need to be different from what you've put in before. It doesn't have to be brand new evidence. It could be a report that's been available for a while, but you haven't submitted it as part of your application before. If it isn't brand new, you need to explain why you haven't submitted it before. Maybe you didn't know it existed. If it's an expert report, maybe you didn't know you needed one. And maybe you got a new lawyer who helped you to find this new evidence that you weren't able to do on your own. It can't be evidence that really you could have submitted at your appeal stage and you just didn't. You held it back. You need to explain why you're submitting it now. The Home Office will look at evidence you've submitted beforehand and look at the story, the testimony you gave beforehand, and will look at whether they think, therefore, you can be trusted. But they're not able to just completely dismiss evidence you're putting in because previously you were found to not be believable. As we've mentioned, it needs to be relevant to your specific situation, and it needs to give you a realistic prospect of success. So the Home Office will do a kind of preliminary look at the evidence and think, well, are you likely to need protection on this basis? That won't be a full decision on that. They won't go into it in substantive detail, but they will look at whether actually is it strong evidence? Does it require a closer look? That's quite an abstract way of thinking about getting the evidence. And perhaps somewhat surprisingly, a useful guide for thinking about your evidence is actually the form you need to submit to the Home Office with your further submissions. And it's not that often that Home Office forms are useful to the person making an application, but in this case, it is quite a useful prompt for certain things you need to consider. So let's have a look at that now. While you do need to use this form to submit further submissions to the Home Office, you can obviously add additional sheets of explanation about your evidence. You're not constrained to the boxes that are on this form. And you can find a link to this form in the Right to Remain Toolkit section on fresh claims. As I said, it is a Home Office form, so the first page talks about voluntary return to your country. Not very helpful start. We can't get away from the fact that this is a Home Office form serving a Home Office agenda. However, once we get past that first page, it becomes more useful. The Home Office say that the evidence should be new, it should create a realistic prospect of success, it should be relevant to you, that it shouldn't have been previously available. So it's kind of laying out those different aspects of that fresh claim test in slightly more accessible language. And then when you actually go into the form itself, it again has some useful areas for consideration. It asks you if you've submitted any of the documents beforehand to the Home Office or to the tribunal. Well, if you have, you need to be thinking about why you're submitting it again. It's not that you can't submit evidence again. So if you're asking for a document to be considered in combination with another new document, it would make sense to include that first document. But if you're only submitting stuff that the Home Office or the courts have looked at before, that isn't going to be accepted as a fresh claim. And just to say about this form, you might find it a bit off-putting that's from 2017 and it refers to the court, the tribunal, in a phrase that we don't use anymore. But this is still the current form the Home Office direct you to. So they ask you to tell them briefly what the further submissions are about. So that's probably where you'll explain what basis of the fresh claim that we talked about. Is it the same reason you claimed asylum originally? Is it about a new reason? Is it about a change of circumstances back home? Is it about something that's happened in the UK? They divide fresh claims, further submissions into 3 broad categories rather than the kind of 4 categories that we've talked about in this video. The first is submission based on a change in your country of claim, which is relevant to you. I think this is a really unhelpful phrase because to me, country of claim sounds like it should be the UK because that's the country you're in making your claim. But actually, the country of claim is the country that you have come from, that you are fleeing from. So the first section asks you if you have evidence based on a change in your country of origin. You don't have to fill this in if that isn't what your fresh claim, your further submissions are about. So it's saying what has changed in your country of origin, and how does this affect you personally? You can't just put in general evidence and expect the Home Office to guess how this links to your asylum claim. You need to make that link. You need to explain, how does this prove that you would be in danger or that something you said in your first application was actually true? The next section of the form looks at submissions to support your previous claim based on evidence which is not previously available. So the same reason you claimed asylum before, but you've got new evidence. Maybe a human rights report, maybe an expert report. The Home Office aren't going to flag up the opportunity to give evidence about your activity in the UK because the Home Office aren't very keen on activity in the UK as evidence. Their position on this tends to be, you've only done that, you've only gone on these protests or gone to that LGBT group or converted to Christianity in order to have a fresh claim. And you should be prepared for the Home Office response being that. And you need to be clear about how this is a genuine belief, activity that you've wanted to engage in and that you're providing evidence of this. You couldn't provide evidence of that before because you hadn't done it before. So they ask you to explain why you didn't give the evidence earlier and why it's significant. So again, not just this is evidence about my activity, why does this show that you need protection in the UK? And then the final part of the form is about a submission based on a change in your personal circumstances, and this is probably likely to mean family members or even health reasons in the UK, and they ask you to say, why does this mean you should remain in the UK? The form then goes on to recap some of those elements we talked about the evidence being new, about being significant, and about being relevant to you and not previously available. So again, quite a useful checklist for what evidence you should be looking for and then how you should be explaining that evidence shows that you need protection and meets the fresh claim test. So you found your evidence, you've used the form to explain how the evidence shows you need protection, meets the fresh claim test. In normal circumstances, you would then have to call the further submissions unit in Liverpool to make an appointment to submit your evidence. I'm making this video at the time of coronavirus where actually the Home Office have changed the rules and you can post or email your evidence. We very much hope they'll keep that system in place. In normal times, you have to call up to make an appointment to go to Liverpool, and people have experienced real difficulties in the past getting through on that phone line, weeks of trying to get through on that phone line. And if they go back to the phone line and you can't get through, some useful advice has been to either write a letter or if you have an email address for them, email the further submissions unit, and they have been found to call you back and book an appointment for you in those circumstances. Tends to work a bit better than just trying to get through on the phone line. So you filled out your form, you've got your evidence, you've submitted your evidence. There are exceptions as well to going to Liverpool in person, even in normal times, and you can find those exceptions here in the Right to Remain Toolkit. I won't go into detail about those now. And then you need to wait for a Home Office decision. This could be a really long time. In 2018, the Home Office average time for a decision on further submissions was 2 months. But I think this is a really unhelpful statistic because I think this figure is quite distorted. It's an average figure. So for some people, the Home Office will make a decision really, really quickly. And this will often be if someone has, for example, removal directions. The Home Office want to remove you from the UK, you've managed to get further submissions in. We've known the Home Office to make very quick negative decisions in those circumstances. Whereas other people we talk to have been waiting 6 months, a year, 18 months. So I think the 2-month figure gives an unrealistic expectation of when you might get a decision. If the Home Office looks at your evidence and says, no, this does not meet the fresh claim test, then that's your fresh claim rejected and you don't get a right of appeal to that decision. You might be able to take out a judicial review of that decision, but you'll likely need a lawyer to help you to do that, and it's quite difficult. But you can challenge, judicially review the decision of the Home Office to say that your further submissions aren't a fresh claim. Another option in those circumstances would be to try and get more evidence, different evidence, better evidence, and submit another fresh claim, another set of further submissions to be considered as a fresh claim. That's the group of people that most people fall into. The statistics we've seen have been about 85% of people have their further submissions rejected as not being a fresh claim. For the minority that don't have that, the Home Office may look at your further submissions and say, okay, we accept that it is a fresh claim. It meets the fresh claim test. We're going to now look at whether or not you need protection in the UK. If they decide that your further submissions are a fresh claim, but that you don't need protection in the UK, they'll refuse your fresh claim, but you get the right to appeal that in the first tier tribunal, like you will have done with your first time round of applying for asylum. Or the smallest group of people, unfortunately, the Home Office might look at your further submissions, say, yes, it's a fresh claim, and yes, we think you need protection in the UK. They might give you an interview, they might just make a decision on the papers, in which case they will grant you refugee status, humanitarian protection, or maybe some other form of leave to remain. Further submissions to be considered as a fresh claim aren't a solution for everybody. Not everybody will have new evidence to make their case, to show that they're in danger, even if they are in danger, even if they need to be in the UK because of family reasons. It is not a silver bullet, it's not the answer, it's not a magical solution, unfortunately, for everybody. But for some people, it can be the thing that saves them, that stops them being removed from the UK, maybe even saves their life. So it is something people need to look at really closely to see if it's something they should be applying for. One of the problems is that people feel quite pressured to put in further submissions quickly after they are appeal rights exhausted. Once your appeal rights exhausted, your asylum support stops, you're at high risk of detention, and the Home Office might try and remove you from the UK. So it makes sense you'd be anxious to have some kind of application in with the Home Office to try and stop those things happening to you. However, a bad fresh claim, weak evidence that clearly isn't going to meet the fresh claim test being put into the Home Office is probably worse than not having an application in at all, because the Home Office can just reject it really quickly, and if perhaps you even go on to judicially review that, the courts can say further fresh claims are not going to be a barrier to you being removed. So in many circumstances, it can be important to actually wait until you can get really good evidence. Maybe get an expert report. This can take time. Maybe take some time to gather your evidence. Maybe you're waiting for news reports, human rights reports, until you can make a really good, strong further submissions. But obviously that can be a really stressful waiting time. But it's just important to remember that while this is a really important stage of the asylum and immigration process, not everyone is going to be able to put in a fresh claim, and certainly not everyone is going to be able to succeed. But do have a look at the toolkit section on fresh claims. Look at our videos on evidence to see if this is something you or someone you're supporting should be considering.